Hello everyone, I'm Debojit Das and welcome to Courts Today by Live Law, your one-stop roundup for the day's most important stories from across the country's courts. The courts were busy as ever, so let's get right into it. Starting with the Supreme Court as it attended to some progress this week concerning the National Security Act detention of Ladakh activist Sonam Wangchuk. The developments combined a legal defense by authorities and a high-stakes clash over his right to legal counsel. The Leh District Magistrate filed an affidavit asserting that Wangchuk was detained on September 26th based on credible inputs and his activities were prejudicial to national security. The DM noted Wangchuk was informed of the grounds but has not yet made any official representation to challenge the NSA order. Furthermore, the Jodhpur jail superintendent confirmed Wangchuk is medically fit, not in solitary confinement, and has been allowed to meet his wife, brother, and lawyer. Crucially, they even provided him with a laptop to prepare his legal notes, despite no prison rules mandating one. In court, senior advocate Kapil Sibal successfully argued for Wangchuk to share his defense notes with his wife. Solicitor General Tushar Mehta conceded no objection to sharing the notes, but expressed a major apprehension. He feared this delay would be exploited to create a procedural ground to invalidate the detention later. The court ultimately directed the union to allow the sharing of notes, but reserved any opinion on the Solicitor General's delay caveat, listing the matter for further hearing. Moving on to a timely update as the Supreme Court has finally scaled back the blanket firecracker ban in the NCR, but it's with a relaxation with a green caveat. A bench led by Chief Justice of India B.R. Gavai will permit the sale and use of only green firecrackers, those specifically certified by National Environmental Engineering Research Institute and Petroleum and Explosive Safety Organization. The catch here, you can only light them between 6 am to 7 am and 8 pm to 10 pm on the day before Diwali and on the day itself. To prevent fakes and smuggled goods, the court imposed strict controls. All sales must be by licensed traders at designated locations, and there is an explicit ban on all e-commerce firecracker sales. Police patrolling teams are now tasked with ensuring only QR-coded, permitted crackers are used within these tight time windows, aiming to balance celebration with clean air. So is this a win for festive spirit or a setback for environmental protection? Comment down below what your thoughts are. Next, we saw the Supreme Court taking on the opportunity to make some major headway in terms of preventing police abuse and custodial deaths in India, directly addressing the establishment's control over the criminal process. The core of the petition is a demand to elevate the right of an arrested person to have a lawyer present during police interrogation. The plea argues that the current watered-down provision, that is Section 41D of the CRPC, which only allows arrestees to meet an advocate, is a deliberate failure to enforce constitutional rights. Petitioners argue that a lawyer's presence is a necessary shield to protect against custodial abuse and prevent coercive statements. This is against the backdrop of alarming incidents, such as those documented in the 2019 National Campaign Against Torture report. The report massively adds to a comprehensive understanding of how common these tragic cases of torture to extract confessions are. Some of them mentioned in the report are the deaths of a 17-year-old boy in Tamil Nadu, Hira Bajania in Gujarat, Karan Kumar in Punjab, Nisar Ansari in Bihar, all tortured to death by the police in theft-related cases. Moving on to another important matter where the Supreme Court issued a critique of the union government, lamenting that it is not ready to evolve on the method of executing the death penalty. The controversy stems from a PIL challenging death by hanging as barbaric, inhuman, and cruel, arguing the current practice causes prolonged pain and suffering, claiming it takes over 40 minutes for a convict to be declared dead. The petitioner is pushing for less painful alternatives, such as intravenous lethal injection, shooting, electrocution, or a gas chamber, noting that lethal injection in particular is used across much of the US and can end life in minutes. The key plea is that the condemned prisoner should at least have the option to choose a quick, humane, and a decent method. However, the union government opposes the move, stating in an affidavit that the issue involves a complex policy decision and that offering an option may not be feasible. This opposition prompted Justice Sandeep Mehta to remark that the government remains tied to a very old, unchanging procedure. The court previously considered forming an expert committee to gather data on the pain and duration of hanging, and the matter is now adjourned until November 11th, leaving the question of a dignified death and the government's willingness to evolve hanging in the balance. From Delhi to Karnataka, as the High Court there expressed their annoyance, for the lack of a better word here, against the misuse of the Right to Information Act or RTI Act, refusing to stay a blacklisting order against a man who filed an astounding 476 RTI applications. In the case of the petitioner Deva Prasad, who sought to overturn the ban imposed by the State Information Commissioner, Justice Suraj Govindaraj remarked, "We cannot allow misuse of the RTI Act," and further noted, "On first blush, filing of 476 applications by the petitioner under RTI Act appears to be quite extraneous." The petitioner's counsel argued that the applications covered different topics and that he was merely exercising his right. However, Justice Govinda Raj was unconvinced, stating, "You cannot be filing 400 applications even if you are a public-spirited person. You cannot misuse this." The court, while issuing notice to the government, directed them to submit details of the nature of the 476 applications filed. The judiciary's intent here is clearly to protect the RTI Act from being exploited, signaling that even though there might be no statutory limit on it, it cannot be misused. The matter is set for further hearing on November 12th. Next, we take a look at a noteworthy development in the Delhi High Court, where Justice Jyoti Singh issued summons to the digital news platform News Laundry in a defamation suit filed by Eduquity Career Technologies. The core of the dispute revolves around a News Laundry article published last year titled "Years Before NEET-RO, NTA Contracted Two Exam Firms with Murky Record." Eduquity, an examination solution provider that recently replaced TCS as a vendor for the Staff Selection Commission, claims the article is highly defamatory. The report alleges that Eduquity's name surfaced in several cheating and paper leak cases. Specifically, it claims that after being contracted to conduct the Madhya Pradesh teacher eligibility test in 2022, Eduquity subcontracted the job to another firm, resulting in a viral exam paper leak on social media. The article further linked the company to later cheating issues during the state's Patwari exams too. Eduquity's counsel argued that the article is being amplified by the defamatory social media videos, causing ongoing damage. News Laundry's counsel, however, is standing by the story, telling the court they are claiming truth as defense. The Delhi High Court has issued summons in the suit and notice on Eduquity's application for an interim injunction, setting the stage for a major legal battle over journalistic claims and corporate reputation. The Karnataka High Court demands our attention once more as it delivered a crucial interim order to protect the dignity and privacy of the transgender community during a state-led transgender survey. A division bench of Chief Justice Vibhu Bhakru and Justice C.M. Punacha immediately restrained the state from conducting any identification using the strip and search method until the next hearing. The court further mandated that participation in the survey must be voluntary and all collected information must be kept strictly confidential and not disseminated. The petition also demands that the state establish a compensation fund for those subjected to forced verification or humiliation, issue a public apology, and fix accountability for the officials who designed and implemented the unconstitutional process. The court has ordered the Department of Social Welfare to file an affidavit detailing the confidentiality method and has posted the matter for further hearing on December 5th. That's all from our side on Courts Today, but remember, to access complete coverage of these stories, visit www.livelaw.in and consider subscribing to the most credible reportage in India. I'm Debojit Das. Thank you for watching.